Sit down. Get him out of the courtroom right now. They're in the courtroom right now.
Unless I'm mistaken, I'm seeing a defendant that's in the middle of an operating room.
Deep down in my heart, I believe that your significant other was an innocent man and did not deserve to lose his life.
A Phoenix woman who was intoxicated when she drove the wrong way on a freeway off-ramp, causing a chain reaction accident that killed a taxi driver near Old Town, was sentenced to 17 years and 8 months in state prison. Amy Marie St. John, 44, pleaded guilty in November to gross vehicular manslaughter while intoxicated and DUI causing injury. Superior Court Judge Louis Hanoyan called the case a tragedy for both the victims and the defendants' families. "There isn't any way that I can fix anything," said Judge Hanoyan. He noted that St. John, who had a prior DUI from Arizona, had been warned not to mix alcohol and drugs. Because of her actions, taxi driver Anthony Manassi was dead, and another man was seriously injured. "That's hard to live with," the judge said, emphasizing that St. John was not a monster and did not intend to drive onto the freeway and kill someone. During the sentencing, a family member of the victims, Stitsazu, addressed the defendant, saying, "I want you to know I do forgive you."
You took away a loving, caring father from 3 beautiful little children. My 5-year-old said to me, "Mom, I wish Dad was alive, at least until I finish kindergarten."
You caused so many people unbearable pain and grief. You murdered Anthony Manassi.
It saved my life, and the only reason why I turned around is because he did say back up.
Luis Munazuri Harris was found guilty by a Tampa jury of grand theft, kidnapping, fraudulent use of personal information, and fraudulent use of a credit card. The courtroom became heated during closing arguments, and Judge Chet Tharp had to order bailiffs to forcibly remove Harris from the courtroom when the 31-year-old began shouting. The bailiffs covered Harris's mouth with their hands as they practically lifted him up to make a hasty exit from the courtroom.
Mr. Harris chose to represent himself at the start of this case. He is not on trial to test his common sense or his intelligence. When she realizes that this guy has her credit cards, she's angry and he's taking her money and she feels like a fool and she's embarrassed by it.
Sit down. Get him out of the courtroom right now. They're in the courtroom right now.
The first trial of Luis Harris in Hillsborough County garnered national attention due to his disruptive behavior in court as he chose to represent himself after dismissing his public defender in 2010. A jury found him guilty of impersonating a police officer and subsequently kidnapping, robbing, and raping a woman along Bayshore Boulevard in Tampa. He was sentenced to life in prison. Ian Brady, born on January 2, 1938 in Glasgow, Scotland, to Margaret Peggy Stewart, an unmarried tea-room waitress, showed troubling behavior from a young age. He developed a fascination for violence and sadism early on, alongside an infatuation with Nazi ideology and dark literature, which likely contributed to his distorted mindset. As a teenager, Ian Brady appeared twice before a juvenile court for housebreaking. He left school at the age of 15 and took a job as a tea-boy in a shipyard in Goa. Shortly before his 17th birthday, Brady was sentenced to 2 years in a Borstal for training and spent 3 months at Strangeways after being caught with a sack full of stolen lead seals he was attempting to smuggle out of the market. Myra Hindley was born in Manchester, England on July 23, 1942. Unlike Brady, she did not have any unusual fantasies and grew up as a modest woman. Unfortunately, this changed drastically after she met Brady. Hindley became so infatuated with him that she was willing to participate in criminal activities. Between July 1963 and October 1965, Brady and Hindley were involved in a series of abductions and murders. Brady and Hindley used various methods to lure their victims, often offering rides or pretending to have accidents to gain their trust. Once captive, they endured unimaginable torment, including assault, torture, and strangulation. Afterward, their bodies were either buried on Saddleworth Moor or carelessly dumped in shallow graves elsewhere. Their spree came to an end when they were arrested in October 1965, thanks in part to the courage of Hindley's brother-in-law, David Smith, who witnessed Brady killing Edward Evans. Subsequently, police uncovered evidence linking the couple to other murders. In April 1966, Brady and Hindley were tried at Chester Assizes. Their trial lasted 14 days and garnered significant attention from national and international journalists, with many booking most of the city's hotel rooms. Unlike the perpetrators, the court prioritized human lives and outfitted the courtroom with elaborate security measures, including bulletproof glass in the dock to protect them. During the trial, Brady and Hindley were charged with the murders of John Kilbride, Leslie Ann Downey, and Edward Evans. However, they both pleaded not guilty. Brady admitted to striking Edward Evans with an axe, but claimed someone else had killed him. Hindley, on the other hand, initially denied knowledge of the photos found near the grave sites of their victims. However, when a tape recording capturing her and Brady's voices was played, she admitted to being present during the crimes against Leslie Ann Downey and John Kilbride. She justified her actions, claiming fear of someone hearing her scream, and offered alibis for her whereabouts during the murders, while maintaining her innocence. On May 6, 1966, the jury found Brady guilty of all 3 murders, while Hindley was found guilty of the murders of Leslie Ann Downey and Edward Evans. Since the death penalty had been abolished by then, both received life sentences. Brady was sentenced to 3 concurrent life terms, while Hindley received 2 life sentences plus a concurrent 7-year term for harboring Brady, knowing he had murdered John Kilbride. After his conviction, Brady was initially housed in Durham Prison, where he initially requested solitary confinement. However, in November 1985, following a diagnosis of psychopathy, he was transferred to the high-security Ashworth Hospital in Maghull, Merseyside. Brady was aware of the severity of his crimes and expressed a desire not to be released from prison. He repeatedly requested to be allowed to die, but when this wish was not granted, he spent years corresponding with individuals outside the hospital, including Lord Longford and several journalists. In these communications, he conveyed his discontent with the conditions at Ashworth Hospital. Brady also went on hunger strikes, leading to instances where he had to be force-fed. In 2001, Ian Brady wrote a book titled The Gates of Janus about serial murder. During his recovery in the hospital, he attempted to return to prison to starve himself to death, but he was unsuccessful. He ultimately passed away in May 2017 from restrictive pulmonary disease, which severely limited his lung capacity. He had served 51 years in prison. As for Myra Hindley, she ceased claiming her innocence and confessed to all her crimes in 1987.
The Moors murderer Myra Hindley has confessed tonight to her part in the death of 2 children who vanished more than 20 years ago.
Myra Hindley made several attempts to appeal her life sentence, but was consistently denied. Before that, she ended her relationship with Ian Brady in 1971 and began a relationship with Patricia Cairns, one of her prison warders. They both attempted to escape, but were unsuccessful. In 1985, Hindley's prison sentence was increased to 30 years, and Prime Minister Margaret Thatcher stated that Hindley would never be released due to the potential harm she could cause if returned to society. The Prime Minister's decision was upheld, and Hindley was never released from prison. She passed away in November 2002 from bronchial pneumonia at the age of 60.
Myra Hindley, probably the most hated woman in Britain, is dead. The Moors murderess died of a chest infection after 36 years in jail.
The Medical Board of California announced it was investigating a plastic surgeon, Dr. Scott Green, who attended a video traffic court hearing from an operating room while dressed in scrubs with a patient on the surgical table. During the video conference for a trial in Sacramento Superior Court, the courtroom clerk addressed Dr. Green saying, "Hello, Mr. Green, are you available for trial?" Dr. Green, wearing a surgical mask and cap, appeared in a virtual square with operating room lighting fixtures visible behind him. The clerk remarked, "It kind of looks like you're in an operating room right now." Dr. Green responded, "I am, sir. Yes, I'm in an operating room right now. I'm available for trial. Go right ahead," as machines beeped in the background. The clerk advised Dr. Green that the hearing would be live streamed on YouTube. After being sworn in, Dr. Green's camera briefly swiveled, revealing a person on an operating table. Gary Link, a Sacramento Superior Court commissioner, appeared on camera and said, "Unless I'm mistaken, I'm seeing a defendant that's in the middle of an operating room appearing to be actively engaged in providing services to a patient. Is that correct, Mr. Green? Or should I say Dr. Green?" Dr. Green confirmed that it was. Mr. Link continued, "I do not feel comfortable for the welfare of a patient if you're in the process of operating that I would put on a trial, notwithstanding the fact the officer is here today." Dr. Green explained that another surgeon was in the room who could perform the surgery, but Mr. Link disagreed.
Unless I'm mistaken, I'm seeing a defendant that's in the middle of an operating room. Is that correct, Mr. Green?
Yes, sir.
I don't think so. I don't think that's appropriate.
I have another surgeon right here who's doing the surgery with me, so I can stand here and allow them to do the surgery also.
Not at all.
He received a sentence of probation for his actions. He was also required to pay a fine of $5,000 and perform community service. Juan Parks, originally from Detroit, was sentenced to 46 to 60 years in prison for the fatal shootings of a Detroit police officer and 2 other men over 4 days in 2019. The 32-year-old pleaded guilty to 2 counts of second-degree murder in connection with the unrelated deaths of Detroit police officers Rasheen McClain and Nathaniel Lloyd. Charges related to the death of Dante Calhoun were dismissed as part of a plea deal made in consultation with the families of all the victims. During Parks' sentencing, Wayne County Assistant Prosecutor Matthew Penny read a letter written by McClain's widow, Heidi McClain, who was present but did not speak. In the letter, Heidi McClain expressed how Parks violently took away an amazing person from her life, friends, and community, giving her a lifetime sentence of pain and grief. She shared her struggle to move forward after her husband's death, noting that she had to retire from her job because she couldn't function, and there are days when she feels she can't go on. She wrote that when she can fall asleep, she sometimes wakes up praying that her husband's death was just a nightmare. Parks declined to say anything before he was sentenced. Police said Parks's obsession with a girl sparked a 2-week shooting rampage. Officer McClain, 46 years old, was shot at a home on November 20th, 2019 on Wyoming Avenue near Chippewa Avenue on Detroit's northwest side.
Case comes on the same day as Officer McClain's family, colleagues, and friends are gathering to remember him.
It's been 1,190 days since the worst day of not only my life, but the lives of so many others.
At this man now accused of and Police Sergeant Rasheen McClain.
For the conduct that has him here today, and
Juwan Parks actually started targeting some of his very own friends, but it was all over a woman's lie.
While responding to a report of a home invasion, Officer McClain and 3 other officers entered a house after being informed that a man with a rifle was hiding inside. The officers checked the top 2 floors of the house and were halfway down the basement stairs when they were fired upon with a Russian-made SKS carbine rifle. McClain was shot in the neck, and his partner, Philip Bottoms, was shot in the ankle. Parks was wounded after the 2 other officers saw him running from the house and exchanged fire with him. He was arrested a block away after the shooting. Wayne County Prosecutor Kim Worthy said, "McClain's death and the wounding of his partner are heart-wrenching and very emotional for all of us, especially McClain's loved ones."
There's no new children to be born. There's no new memories for them to create.
We know that the work continues relative to this very dangerous suspect.
Violently took away from us an amazing husband, father, papa, son, nephew, friend, police officer, and community mentor.
To Juwan Parks, the family of Nathaniel Lloyd has started a GoFundMe account to help pay for his funeral.
I believe that he's extremely remorseful.
And right here at 7 Mile in Wyoming, he allegedly shot one man in a case of mistaken identity.
All of their memories in this world that their family has stopped.
A Delaware County judge sentenced Todd Mullis to life in prison without the possibility of parole. In 2019, a jury found him guilty of killing his wife, Amy Mullis, with a corn rake on their Earlville farm in November 2018. The sentencing hearing was delayed 4 times due to the COVID-19 pandemic and Mullis acquiring new lawyers. Before being sentenced by Judge Thomas Bitter, Mullis proclaimed his innocence, stating, "This is supposed to be America where you have a fair chance of proving your innocence. I thought it was innocent until proven guilty. I feel this was the other way around." After the sentence was announced, Amy Mullis's family huddled together, embracing one another. Delaware County Prosecuting Attorney John Bernau commented, "Fortunately, today we were able to get across the finish line and get justice for Amy. Hopefully, this is going to provide some closure." Bernau and his wife knew the Mullis family personally. "My wife had worked with Amy, and I'd gone to her 30th birthday party out at their farm," he said. "She was a kind woman." For Bernau and the prosecution, it has been a long time coming. "This file has been open on my desk for a long time, and I am looking forward to having it closed," he said. "I feel terrible for her family. It is terrible to lose a child under any circumstance, but to lose her to somebody who, at one point, said, 'I will love, honor, and cherish you forever,' and then to turn around and do something like this is truly horrific."
We, the jury, find the defendant, Todd Michael Mullis, guilty of the crime of murder in the first degree.
There's clearly something wrong in Washington state, as yet another courthouse witnessed an audacious and pointless escape attempt. This time, it featured a convicted meth user named Gerald Hyde II and the world's least attentive guard. Shortly after the day's proceedings concluded, a group of prisoners was herded into a room adjoining the courtroom where they were supposed to wait before being transported back to prison. The guard, looking as alert as a freshly tranquilized bear, shuffled to the other side of the room, leaving the door to the courtroom open behind him. Still handcuffed and wearing an expression that might be roughly translated as, "Me? Escape through this very door that yawns so invitingly before me? You are mistaken, sir." Gerald Hyde II strolled backward through the door while the other prisoners pretended not to notice. He then ran through the empty courtroom, stripping off his prison-issue shirt and kicking off his prison sandals to scamper barefoot through the courthouse corridors. Not a single person challenged him as he left through the front door, despite looking more like an escaped convict than any escaped convict has ever looked in the history of escaped convicts. Hyde II's cleverness didn't last long, though. A few hours later, he was caught because he chose to hide out at the home of a known associate. Gerald Hyde II was sentenced to 15 years in prison for attempting to escape from court while facing charges related to a robbery. The story of Richard Wershey Jr., better known as White Boy Rick, is a compelling narrative of a life intertwined with crime, punishment, and a quest for justice. At a young age, Wershey was reportedly coerced into becoming an informant for the police, making him one of the youngest informants in FBI history. However, his involvement with the law took a dark turn when he was arrested for possessing 8 kilos of cocaine. Over the next 3 decades, Wershey fought tirelessly for his release. In a pivotal 2017 parole hearing, he delivered a passionate plea expressing remorse and outlining his determination to steer others away from his mistakes. His heartfelt words resonated with many, shedding light on the harsh realities of the American criminal justice system, particularly its treatment of juveniles and nonviolent drug offenders. Richard Wershey Jr. was sentenced to life in prison for his role in drug trafficking as a teenager. However, he was released from prison in 2020 after serving nearly 30 years, following a reduction in his sentence due to changes in Michigan sentencing laws. The trial of Rodney Reed, an African-American man convicted for the 1996 murder of Stacey Stites, a white woman, captured widespread public attention due to both the contentious nature of the evidence and the broader implications of racial bias in the judicial system. Reed's conviction largely hinged on the presence of his DNA on Stites' body, but he argued that this was due to a secret romantic relationship between them, a claim that intensified the already racially charged trial. In 2019, Reed's case garnered renewed scrutiny when new witnesses and potential evidence emerged, raising doubts about his guilt. This development prompted a last-minute stay of execution granted by the Texas Court of Criminal Appeals. The Reed case has since been the subject of numerous documentaries and investigative reports, with trial footage available online. Rodney Reed was sentenced to death for the 1996 murder of Stacey Stites. However, his case has garnered significant attention and controversy, leading to multiple appeals and a stay of execution. In 2021, Texas authorities agreed to review new evidence, which has raised questions about his conviction. The next female officer on our list, Shania Begum, was caught on camera having a sexual relationship with an inmate. Begum began her role as a prison officer at HMP Birmingham in December 2018, a facility known for housing some of the country's most challenging inmates. Her responsibilities included overseeing prisoners, ensuring their safety, and enforcing strict regulations. However, over time, the boundary between professional conduct and personal involvement began to blur for Begum. Like others on this list, she became romantically involved with an inmate named Joshua Mullings. Their relationship started innocently, but evolved into a secret affair. They found an unexpected spot for their meetings: the store cupboard. Usually designated for storage and organization, it was often empty, providing Officer Begum and inmate Joshua Mullings with a discreet place. According to court records, in this unlikely setting, Begum and Mullings engaged in various activities. They carefully hid their secret meetings from colleagues and the prison's surveillance systems. However, their actions only escaped notice for a short time. Suspicion among prison authorities led to installing a hidden camera in the store cupboard. This camera eventually captured evidence of their sexual activities, providing undeniable proof of misconduct. Between September 22nd and 28th, 2020, the newly installed camera recorded Begum and Mullings engaging in various sexual activities. This evidence violated professional conduct and constituted a serious breach of the law, given Begum's role as a public officer. Legal proceedings against Shania Begum began following the discovery of the footage. The case proceeded to Birmingham Crown Court, where Begum admitted to misconduct charges in a public office. She was subsequently sentenced to 16 months in jail. On March 7, 2024, a probation officer was arrested for engaging in an affair with an inmate at the Dorothy Kirby Center in Commerce, a juvenile detention facility in Los Angeles County. While the department did not initially name the officer in their statement, an anonymous law enforcement source confirmed to the LA Times that it was Officer Rafaela Martinez, a 51-year-old probation officer with many years of service at the center. The investigation into Martinez's alleged misconduct began when a cell phone was found in the possession of a youth in custody at the center. This discovery yielded intimate and incriminating evidence. Texts and photos of a sexual nature revealed an inappropriate and illegal relationship between Martinez and the detained youth. Some of these communications were suspected of occurring while Martinez was on duty, blurring the lines between professional conduct and personal indiscretions. Due to the inmates' young age, their identities are currently withheld. Martinez's identity is also being hidden in official statements. Martinez's arrest swiftly followed the discovery of this damning evidence. In addition to charges related to sexual misconduct, she was accused of smuggling a cell phone and a prescription medication bottle into the facility, items considered contraband in a controlled jail environment. These allegations compounded the severity of her alleged crimes. As the case progressed, it had yet to be presented to the LA County District Attorney's Office, but public opinion was already vocal. County leaders, such as Supervisor Lindsay Horvath, condemned Martinez's reported actions unequivocally, describing them as heinous and demanding swift action from law enforcement. The Dorothy Kirby Center, where Martinez's alleged misconduct occurred, faced scrutiny, and Los Padrinos Juvenile Hall in Downey was at risk of closure later that year. Martinez's arrest also shed light on at least one other allegation of misconduct involving a probation officer under investigation by county officials. Earlier in the year, a youth alleged that a female officer attempted to initiate a romantic relationship with him shortly after his release in late 2023. Rafaela Martinez, a probation officer, was sentenced to 10 years of probation after being arrested for engaging in an affair with an inmate. She also faced additional requirements, such as community service and counseling. On December 27, 2022, in St. Paul, Detwan Allen took the life of Alex Becker. Now, Allen faces the consequences of this tragic crime in court. Before sentencing, the judge allows Allen to speak, which may influence the final decision on his sentence.
I want to send my condolences to Alex Becker's family. I'm sorry. I'm sorry for your loss. I didn't have any knowledge that these events would occur. Deep down in my heart, I believe that your significant other was an innocent man and did not deserve to lose his life.
All right. With that, Mr. Allen, we did have a trial. The jury convicted you of count 1, which is second-degree murder with intent, and the court, if not done so, will adopt that guilty verdict, adjudicate you guilty of that count. Related count 2, which is the felony murder, that's you are acquitted of that, so that count is dismissed at this point. So we're going to proceed to sentencing on count 1. And Mr. Allen, I sat through the trial. I hear the testimony. I consider the argument that the attorney had made. I consider the statement that the family had provided to me. And to the family, I just want to thank you for being here to provide statements, to share with the court as well as the state about who Alex Becker is. and what he mean to you, what he mean to the state. So I appreciate that. I don't know if this will be a closure to you, but hopefully he will bring accountable to the people that was involved in this incident. So whether that's a closure or not it's a phase that you go through. And again, my hope is that we'll bring accountable to the people that are involved in this case. So again, I appreciate the time that you took to be here and also provide the statement to the court. And Mr. Allen, I did see a lot of evidence in this case. Even prior to this actual incident, the state present evidence, video surveillance video of you at the apartment complex. And almost every time I saw you, you also cover your face with a skiing mask sort of cover every time. When you're indoor, when you go to the elevator, when you go open the door for someone, when you go to the store. There's only a few times that you take off the mask that the state's able to present your actual face. And the mask is not your typical, concern about your health mask when you cover your nose, your mouth. It's only cover it doesn't cover your nose wide open. It just covers everything else. You can only see your eyes and your nose. And it's harder to identify you that way. And I think that goes into why you put yourself in this situation. You're also ready to get involved in criminal activity. I think that's the only reason why you constantly cover your face at the store, everywhere. Not concerned about your health and covering your nose way exposed the whole time. So what led to this night? The night that Alex Becker was killed, the state will summarize the facts. And all murder cases are senseless, including this one. And a lot of the time, however, at time we're able to categorize as gang-related murder, robbery murder, drug deal murder, could be domestic, assault-related murder, shooting. From the outset in your case, it's like a robbery shooting, and I say from the outset. But when we look deeper into what happened in this case, as the state summarized the fact already, I don't need to do that. From the sound of the gun appeared, though, it does appear that you have plenty of time. 4 shots were fired, then there's a pause. Then another 3 shots were fired, then there's another pause. There's 1 more shot. And that showed me that he's not fighting back. You and your co-defendant keep shooting him. Take your time to shoot him. You're not in a rush. Usually people in gang-related shit, they fire as they run. You guys didn't even run. You keep shooting at him, take your time. So that showed me that is even beyond an execution. He's your target practice. Because you took your time. And you fire at least 7 shots at him. Take a pause in between. And again, we look deeper. You clearly have your time, the 3 of you. The police found in his wallet, it's all cash in it. Not a whole lot of cash, but clearly he has money in his wallet. You didn't touch it. You didn't want the cash. So from the outset, it looked like a robbery. But when you really look closer at the evidence, it's like you guys are hunting. You chase down your prey, you surround him, and you shoot the prey as your target practice. And this is a human being we talk about, Mr. Becker. Not only, as the state again pointed out, not only you led the chase, led the kill, you also led the escape. You got in the car first, and the other 2 guys just running like deer in a headlight. They don't know where they run. We saw the video. They run back and forth the same spot. Not until you pick them up that they're able to get away from the scene. So the court clearly see that you play a more significant role in this murder. You actually led the chase, led the getaway, and you will deserve the most punishment as required by law. So based on your conviction, guilty verdict, the court's going to order you commit you to the commissioner to serve 367 months. With that, 2/3 had to be served in custody. The remaining 1/3 may be served in supervised release. You'll be given credit for 444 days. The court's going to grant the restitution, the federal expense restitution. The court's going to grant Ms. Becker's request for restitution amount, and the court further is going to keep restitution open for 90 days from today's. So additional restitution will be submitted for consideration. And the court's rather have any money you have go toward the restitution. I'm not going to issue any fine. There'd be a surcharge of $86 in this case. Again, I want the restitution to pay, and that's why I don't assess any fine. I believe that DNA sample already on file, so I don't have to order that. Missing anything further?
Your Honor, I think that covers it. You are ordered both restitution requests. I believe that's everything.
Mr. Pleasure.
Would Your Honor waive the public defender fee?
If there's a fee, I'll waive the public defender fee as well. I'd rather have the money go toward the restitution. So, all right, with that, the sentence concluded. And if for the family going to leave the courtroom, please follow the direction. The deputy, they're going to tell who to leave first, so just don't get up and follow the direction. And with that, the sentencing on Mr. Allen's case concluded.
Detwan Allen was sentenced to 40 years in prison for the murder of Alex Becker. In October 2016 at Winter Park in Florida, Simeon Hall and Jesse Sutherland tragically took the life of a teenager named Roger Trindad. The loss of a family member is a pain that no relative can easily overcome.
Roger was our only son, a boy full of life, always with a smile on his face. He was born and grew up in a loving family, and used to say that a simple gesture of affection could brighten a person's day. He was loving, polite, generous, always ready to read out to anyone in need. Moving to USA was a life experience for him, a unique opportunity to learn about the culture, history, and country. As his teacher in Winter Park High School stated, Roger was the American dream. He was determined to have a good education and had energy and passion to learn. Roger was a boy with full abilities that we are very proud of him. Bullying is an aggression that cannot be accepted in any way, anywhere around the world. Roger was moved by the irresponsibility and the levity of many. We hope that the ones responsible receive the maximum applicable penalty. We hope that justice can send a strong messenger and clean to all violent and aggressive juveniles involved in this case. One cannot play with the lives of others. This kind of hostility to an innocent child is not acceptable and should be punished as law requires.
A father should never have to endure the loss of his son, but for Roger's father, this tragic reality became his burden to bear.
Why? I can only say hate. They hated them because they were strangers. And they come up with absurd force against a tiny, skinny child that had no fighting skills. The skills were on his brain. He was educated to be a good citizen, to be a good husband, future husband, a good father that he would be. Were they brave? No, they were cowards. Cowards to attack a little child, half of his size. And it was not only the two of them, it was over 15. It was a group of people, so my son could not do anything. He just couldn't defend himself. This is the picture I have in my mind. There's no motivation. It's a brutal attack with pure hate and anger. The second part is, my son is gone, there's nothing that can bring him back. Even if you could punish all mankind, he would not be back. So what's at stake now? How should you punish them? Truly, to us, it's not going to change anything. So I think this is about how much you want to protect this community and this society here from them, because they did that with no motivation, with hate, only hate on their hearts. That's all they had. And now it's up to the system to decide how much or how long you want to protect the other kids that are still here. How long you want to protect them from the hate of others. It's your decision.
Thank you. On behalf of Mr. Sutherland? No, on behalf of Mr. Hall? No, ma'am. Thank you, sir. You may step down. That friend has been, my understanding, sentenced in juvenile, with juvenile sanctions. All of us are more than just our worst day. A kid who steals something, candy from a store, isn't a thief and isn't a thief forever. We're more than just what our worst action was. Knowing that, and knowing that all people are required to have hope, redemption, and certainly children. That's what we base it on. And understanding all that, the difference between the system, the difference between the adult system and the juvenile system is not which one's most minor. It's not even true. That's actually not true, because in this situation, a youthful offender, which is an adult sanction, could be probation or a fine and no supervision whatsoever. So it's not about which one's most minor. It's about the juvenile system is there to help children become productive adults with resources that they have, with evidence-based ways that we can do that in society. The adult system is there to punish. If one sentence, if one justice could inoculate children from having to face such fear of going out and getting hurt, if one sentence that I could make here could stop that, or somehow get people who are out there doing behavior like bullying or fighting, and it would stop it, it's an easy decision. You just sentence them to the max. If that just fixes society in that way, that would be great. But one sentence can't, and there's no power in that, and there's nothing that shows, and there's no evidence that shows that what we do here, and the evidence is exactly the opposite. It does not have deterrent effect. And it's not what our juvenile system's based on, and it's not what our adult system's based on. We don't ascribe to deterrence because we know it does not work as we do it in society. We know that. So although it might make everyone feel better, it's not what we do. And with that, after evaluating all the information and listening carefully, and the court, as well as all the people struggling with what is the best decision in this case, I am in fact going to impose juvenile sanctions. Now, my question at this point, I do know I'm not going to follow the staffing that was done. I do know that it was done at the end in a rushed manner, although I think that the information provided was really helpful, good information with a lot of tests. I think the last part of it was clearly rushed. being I got it after 5 o'clock last night. I know it was rushed, and not everyone had the opportunity to present everything they want. The school didn't have the opportunity to be there. They had the records from the school, but they didn't have all the information from the school. There wasn't the opportunity given that should be given. And that's true for Mr. Sutherland, where the state needs more opportunity for that staffing. It's also true for Mr. Hall, where clearly Mr. Hall should have an opportunity, and his attorney should have an opportunity to present what they need for the staffing. So I'm going to order another staffing. And that's where we are at this point. And with that will the attorney's approach.
Both defense counsels wish to have the doctors' evaluations of their private evaluators taken into account at the case staffings. Then they would need to obtain those. We don't have access to those at this point, but those doctors will testify here, but the person who would be conducting the case staffing was not here to hear that either. So that information would need to be gathered and provided. So I would say at least 2 weeks. It might be able to be done sooner if everything can be coordinated, but I'd ask for at least 2 weeks for that.
On January 28, 2018, in Columbus, Anthony Pardon ended the life of Rachel Anderson.
The state in this case will prove to you, and will prove it beyond a reasonable doubt, our burden of proof, that back on January 28th of 2018, a little more than 2 years ago, that the defendant, sitting right there in the middle between Mr. Thomas and Miss Dixon, kidnapped and murdered Rachel Anderson. January 28th was her birthday. She was 24 years old on the day she was murdered by this man. She moved here to Columbus because she's from Warren, Ohio. She moved here to Columbus as an intern at the Shaw Davis Funeral Home. She had gone to school in Cincinnati to get a mortuary education to work in a funeral home, and part of that process requires employment with a funeral home once you graduate from a college. And so she came here. She came here with a friend of hers, another student from that school in Cincinnati, Mr. Sean Griggs, and they jointly rented an apartment out at 3044 Allegheny, out in the east side here of Columbus, kind of in a pocket between Columbus and Whitehall. And both signed a lease, both were on the lease, and that will be important as we go through the testimony. He eventually moved out, and she lived there by herself as she was continuing to work there at the Shaw Davis Funeral Home. As I mentioned, she was from Warren, Ohio, and as her birthday, her 24th birthday, was approaching, plans were made to have a birthday party. And her brother, John, came in town for the birthday party, got here on Friday, the 26th of January. And Rachel had some friends here in Columbus, only friends in Columbus, that her best friend in high school, Haley Kennedy, his brother, John Kennedy, and his wife lived here in Columbus. And so when Rachel moved here, that was the only person besides people she later met at the Shaw Davis Funeral Home that she knew. And so they immediately got together. They had known each other for years. They had all gone to Warren G. Harding High School up in Warren, and so they were friends, and so they made plans to meet on Saturday night, which was the 27th, and have a birthday party for Rachel. Rachel worked that Saturday, and because her brother was here from out of town, she apartment that she lived in worked by key. You had to have the key to lock it, whether you were coming or going. And so she gave her brother John that key while she went to work on Saturday, the idea that he would perhaps come and go, and he did. And so they went out that night. They met originally over at John and Tina Kennedy's apartment out by the casino on the west side here in Columbus. And as any birthday party may involve, they played music, they drank, and they smoked some weed, which was at the residence out on the west side. Some of them later went out to some other locations, clubs, and later returned to the residence out on the west side. They actually, John and the victim, Rachel, stayed out there that night and then went home out to 3044 Allegheny on Sunday morning. And John, her brother, made plans to go back to Warren. He left around 1 o'clock in the afternoon, forgot to give her her key back. So John is on his way back to Warren and let his sister know that, gee, the only key that Rachel had was with John on his way back to Warren. Luckily, Rachel had an extra key that Sean Griggs had when he lived there with her, which she had given to Tina and John Kennedy. And so she texted them about 1 in the afternoon, says, Brother John left with the key. Can I come out and pick up the extra key you have? And they texted back that one of the people who was here for the birthday party went to OU down in Athens, Ohio, and that John and Tina were going to give him a ride back to Athens. And so they texted her back and said, we're taking this fella who was here for the birthday party back to Athens. We won't be back here in Columbus till about 5:15. And so Rachel went about the rest of her day and then talked to her mother. Her mother, Trish, who lives in the Warren area, around 6:30 p.m. And shortly after that, texted the Kennedys and said, I'll be on my way soon to come out and pick up the key. And we know that Rachel talked to her mother about 6:30.
The defense presented various details about the incident in an effort to prove the suspect's innocence. The accuracy of this information would depend on the evidence and arguments provided during the legal proceedings.
Pieces of the puzzle. The theme of this case. Pieces of a puzzle. Connecting the dots. As Judge McIntosh told you, Mr. O'Brien will admit, what I'm about to say and what he said is not evidence. The evidence in this case will come from here. You look, and the thing you have to be wary of, and what me and my co-counsel relied upon, Mr. Pardon relied upon, was your answers in terms of you promised us that you would listen, that you would pay attention as we discussed to all the details. The thing that's very harmful is if you already have your mind made up, or you base your considerations on three things, which Judge McIntosh should tell you, and he's going to give you instruction on, it's not proper. You cannot be influenced by sympathy. So you see what happened out here, and everybody knows as a human being, you're going to feel something. But you can't base your decision on how you view the evidence because of what happened to her. You can't base it on bias. Why? Because when you're filling in pieces of a puzzle, If you already are filling in these pieces based on the bias, you are going to supply the missing pieces for the statewide. If you're looking at this and say, well, you know what, no, this should, you are not going to hold the state to their burden. You are going to start filling in pieces. When pieces are missing, they got to show you a picture of an ocean with a boat, and all you see is blue, and you feel a certain way, you'll fill in that boat. The state of Ohio, in the puzzle that they present to you, have an obligation to fill in every piece of the puzzle. Not for you to come in and be a detective and solve anything. You don't have to solve nothing. If they don't present this picture to you complete, then you must acquit. It's not connect no dots and dots and dots. If you're not convinced that this puzzle is complete, you took an oath that you would acquit. Why do I say that? This is not a one-way street. This is going to be a two-way street. It can only be a two-way street if you're willing to listen, and as you all took an oath, not make up your mind prematurely. How many people will conclude after opening statement that my client is guilty? And you haven't heard not one piece of evidence. Not one. Your job is to keep an open mind. Because somebody said they're an expert, does that mean they're an expert? There are going to be gaps that need to be filled. And the state of Ohio has to fill them. I'm not going to go over each and every testimony here now. But you promise you will be open-minded and listen carefully to the testimony as is given from the witness stand. Listen very carefully to each witness and what they have to say. What was going on the night before, what was going on Sunday, what was going on Monday. Look at the evidence that actually pertains to every part. Not evidence that the state wants you to jump into. Well, we want you to assume. This is not an assumption.
All rise for the jury. This is my first opportunity to say, well, now, good afternoon, everyone.
Good afternoon.
It's my understanding that you have reached a verdict in this phase. Is that correct?
Yes.
Okay. Mrs. Harper? Thank you. Outweigh the mitigating factors beyond reasonable doubt, hereby unanimously return the following life sentence, life imprisonment without parole, and what appear to be 12 signatures. Verdict 3B, we the jury being deadlocked and unable to agree on whether the aggravating circumstances outweigh the mitigating factors beyond reasonable doubt, hereby unanimously return the following life sentence on count 3, life imprisonment without parole, and what appear to be 12 signatures. We, the jury, being deadlocked and unable to agree on whether the aggravating circumstances outweigh the mitigating factors beyond a reasonable doubt, hereby unanimously return the following life sentence on count 5, life imprisonment without parole, and what appear to be 12 signatures. Life sentence on count 7, life imprisonment without parole, and again, what appear to be 12 signatures. Verdict 9B, we the jury being deadlocked and unable to agree on whether the aggravating circumstances outweigh the mitigating factors beyond a reasonable doubt, hereby unanimously return the following life sentence on count 9, life imprisonment without parole, and what appear to be 12 signatures. All the verdict forms are dated today's date, the 20th of February. Either side wish the jurors to be polled. I'm going to ask if you please just wait back there so that I can come back and thank each and every one of you personally for your time and service. All right. Anything else for the record on behalf of the state?
No, Your Honor.
I do want to set the matter out for a sentencing date that's convenient for everyone. I would appreciate counsel discussing the possibility of moving forward today. But with the issues of merger, with the issues of consecutive, with the RVO spec, with the other specs, I want to make sure that I get the sentencing correct. So I don't think I need more than 2 or 3 weeks. I know that you indicated that you're out of town, Mr. Thomas.
That's correct, Your Honor.
The judge sentenced Anthony to life without parole for aggravated murder and an additional life without parole sentence for intimate assault. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.